The phone records show 14. 14 times DeCarlos Brown Jr. was arrested, charged, or ordered for evaluation before August 22, 2025. 14 documented chances for the system to intervene. On the 15th encounter, he wouldn't be the one in handcuffs. Irina Zarutska would be dead on a Charlotte train, and everyone would ask the same question. How did we miss this? At 9:55 p.m. on August 22, 2025, surveillance cameras on Charlotte's Lynx Blue Line captured the attack in clinical detail. DeCarlos Brown Jr., wearing a red hoodie, pulled a folding pocket knife and stabbed Irina Zarutska 3 times from behind, once in the neck, twice in the torso. She had been sitting quietly in her work uniform, returning home from an evening shift. The attack lasted seconds. Brown didn't run. He calmly exited the train with a fresh cut on his hand, walking directly into the waiting police officers on the platform. When officers arrested him moments later, Brown offered an explanation that would become central to his case. He claimed a mysterious material inside him had compelled the attack. He insisted repeatedly that he didn't know the woman he had just killed. The surveillance footage supported this claim. The cameras showed no interaction between Brown and Zarutska before he stood up and attacked her. This wasn't a confrontation that escalated. This wasn't an argument that went too far. This was sudden, unprovoked violence against a complete stranger. The Charlotte-Mecklenburg Police Department's initial response was swift. Officers secured the scene, recovered the knife, and transported Brown to a hospital for his hand injury before formal booking. The train operator had followed emergency protocols perfectly, holding the train until police arrived. Every procedure was executed correctly. The system worked exactly as designed, after the murder had already occurred. Irina Zarutska's journey to that train began in a bomb shelter in Kyiv. When Russia invaded Ukraine in 2022, the 23-year-old art restoration student faced an impossible choice: stay and risk death, or leave everything behind. She chose survival. She chose to flee with her family to Charlotte, where relatives had offered them shelter. The FBI would later document what happened next. Within weeks of arriving in Charlotte, Zarutska had secured not 1 but 3 jobs. She worked at a senior living center, where residents remembered her kindness. She cooked at a pizza shop, picking up extra shifts whenever possible. She cared for pets, building a client base through word of mouth. While working these jobs, she enrolled in college courses, determined to rebuild the education the war had interrupted. Her family described her routine with a mixture of pride and grief. She would leave their shared apartment before dawn and return after dark, always in her work uniform, always exhausted, but never complaining. She sent money back to Ukraine. She helped other refugees navigate the American bureaucracy. The phrase appears repeatedly in witness statements. She loved to help people. On August 22nd, she boarded the train at East-West Boulevard Station, just another commute home after another long shift. She sat down, visible on camera, unaware that DeCarlos Brown Jr. was watching her. Brown would later tell investigators he didn't know her name, didn't know she was Ukrainian, didn't know she was a refugee. To him, she was just a target. The randomness of this selection, the arbitrary nature of who lives and who dies, would haunt everyone who learned about the case. 55 days before the murder, on July 28, 2025, a North Carolina judge signed an order that should have changed everything. The order directed DeCarlos Brown Jr. to report for a community forensic evaluation. The language was clear. Brown was to be evaluated for his mental competency. The system had identified him as someone who needed psychiatric assessment. The order originated from Brown's increasingly erratic behavior. Court documents reveal that his public defender had requested the evaluation after observing signs of severe mental illness during legal proceedings. The judge agreed. The paperwork was filed. The order was entered into the system. And then, nothing. North Carolina's mental health evaluation system operates on multiple tracks. Community evaluations, like the one ordered for Brown, average 3 weeks to complete. Hospital evaluations take over 2 months. Brown's evaluation fell into a bureaucratic gap. He was supposed to report for evaluation, but the order contained no enforcement mechanism. There was no follow-up scheduled. No one was assigned to ensure compliance. The state would later acknowledge this systematic failure. In North Carolina, judges can order evaluations, but they cannot compel attendance for non-emergency cases. The evaluation order becomes just another piece of paper unless the subject voluntarily complies or commits another crime. Brown did neither. He simply didn't show up. By August 22nd, the evaluation order was still pending in the system. the psychiatric assessment that might have identified Brown as dangerous, that might have led to involuntary commitment, that might have connected him with medication and treatment. It never happened. The judge's order, designed to protect both Brown and the public, had become just another document in a file, another missed opportunity in a long chain of failures. DeCarlos Brown Jr.'s first documented encounter with law enforcement came in 2007. He was 17 years old. The charge was minor, a misdemeanor that would typically result in community service or a fine, but it marked the beginning of a pattern that would span 18 years. The records from 2007 to 2014 tell a story of escalation that seems obvious only in hindsight. Encounter 2, burglary. Encounter 3, larceny. Encounter 4, assault. Each arrest resulted in minimal consequences, suspended sentences, time served, probation. The system treated each incident as isolated, never connecting the dots to see the emerging pattern. The fifth encounter changed everything, though no one recognized it at the time. In 2014, Brown was arrested on federal weapons charges. Federal prosecution would have meant serious prison time, comprehensive mental health evaluation, and a paper trail that followed him anywhere in the country. Instead, prosecutors offered a plea deal. The federal charge was dropped in exchange for a guilty plea to state robbery charges. Criminal justice experts would later call this the first catastrophic missed opportunity. The federal charge would have triggered mandatory psychological evaluation. It would have placed Brown in a system with more resources for mental health treatment. It would have created the kind of criminal record that prevents future weapon access. Instead, the plea bargain sent Brown into North Carolina's state system, where he would serve time but receive minimal psychiatric care. This pattern, arrest, minimal consequence, release, created what prosecutors call system fatigue. Each encounter generated paperwork, but not intervention. Each arrest added to his record, but not to anyone's sense of urgency. By 2014, Brown had established himself as a repeat offender, but not one who attracted special attention. He was processed through the system like thousands of others, his mounting mental health issues invisible in the paperwork. The 2015 robbery with a dangerous weapon changed DeCarlos Brown Jr. in ways that everyone could see, but no one could fix. The crime itself was serious. Brown had threatened someone with a weapon during a robbery. The judge sentenced him to 5 years in prison. But what happened during those 5 years would transform Brown from a repeat offender into something far more dangerous. Prison medical records document the diagnosis: schizophrenia. The onset appears to have been rapid and severe. Brown began hearing voices. He described feeling controlled by outside forces. He spoke of materials and energies that commanded his actions. Prison psychiatrists prescribed antipsychotic medications, but medication compliance in prison is notoriously difficult to maintain. Brown's mother would later describe visiting her son during this period. The man she saw was not the son she had raised. He had become paranoid, aggressive, unable to maintain coherent conversation. She watched him deteriorate week by week, month by month. She begged prison officials for help, for treatment, for anything that might bring her son back. The response was always the same. He was receiving the standard level of care available to all inmates. When Brown was released in 2020, he returned to a world unprepared for his transformation. The schizophrenia that had developed in prison didn't disappear when he walked out the gates. His family tried to manage him at home, but his violent outbursts and paranoid delusions made it impossible. His mother would later tell investigators about finding him talking to invisible people, about him accusing family members of plotting against him, about the fear that gradually replaced love in their home. The system that released Brown provided no transition plan for his mental health care. He was given a 2-week supply of medication and a list of community mental health centers. No appointments were scheduled, no caseworker was assigned, no one followed up to ensure he continued treatment. Within months, Brown was off his medication, living in increasing isolation, his schizophrenia untreated and worsening. January 2025 brought Encounter 12. Brown was arrested for misuse of 911, calling emergency services repeatedly without cause. In North Carolina, this is a misdemeanor that typically results in immediate release on a promise to appear in court. Brown was processed and released within hours. No one checked his psychiatric history. No one noted his previous weapons conviction. No one connected this minor charge to his pattern of escalation. The The January arrest represented a critical missed opportunity. Brown was in custody, however briefly. A comprehensive background check would have revealed his violent history and mental health diagnosis. A psychiatric hold could have been requested. At minimum, his release could have been conditioned on mental health evaluation. Instead, he was processed like any other misdemeanor defendant and released back onto Charlotte's streets. February 2025 brought Encounter 13, though this time Brown wasn't under arrest. His family, desperate and frightened by his deteriorating condition, attempted to have him involuntarily committed. They filed the paperwork, appeared before a magistrate, and described his violent behavior and paranoid delusions. They begged the system to intervene before someone got hurt. The magistrate ordered a temporary psychiatric hold. Brown was taken to a psychiatric facility for evaluation. But North Carolina law requires strict criteria for involuntary commitment. The person must pose an imminent danger to themselves or others. After 72 hours of evaluation, during which Brown was medicated and stabilized, doctors determined he did not meet the criteria for continued involuntary commitment. He was released. His family was devastated. They had done everything right, followed every procedure, begged every official. But the law's narrow definition of imminent danger meant that Brown's general pattern of violence and deterioration wasn't enough. He hadn't threatened anyone specific. He hadn't attempted suicide. He was sick, everyone agreed, but not sick enough for the law to keep him hospitalized against his will. After the failed commitment attempt, Brown's family faced an impossible choice. They couldn't manage him at home. His violence made that clear. But they couldn't force him into treatment either. Eventually, they arranged for him to stay at Roof Above, a men's shelter in Charlotte. It was the only option left, a place where at least he would have food and a bed, even if he wouldn't get the psychiatric care he desperately needed. On September 2, 2025, federal prosecutors announced charges against DeCarlos Brown Jr. under Section 1992 of Title 18 of the United States Code, violence causing death on mass transit. The potential sentence, death. President Trump's response was immediate and unequivocal. At a September 9th press conference, he called Brown deranged and explicitly called for the death penalty. He will never again see the light of day as a free man, Trump declared. But the question of Brown's fate misses the larger point. The 15th encounter, the one where Brown finally committed murder, was preventable at 14 different points. Each arrest, each evaluation order, each family plea represented a chance to intervene. The system had 14 opportunities to recognize the danger Brown posed and take action. It failed every time. The accountability trail leads in multiple directions. The July 28th judge who ordered psychiatric evaluation but included no enforcement mechanism. The prosecutor who plea bargained away the 2014 federal weapons charge. The psychiatric facility that released Brown in February despite his family's warnings. The jail officials who released him in January without checking his violent history. Each decision was defensible in isolation. Together, they created a pathway to murder. Mecklenburg County officials have promised reviews and reforms. They speak of closing gaps in the mental health evaluation system, of better coordination between criminal justice and psychiatric services, of new protocols for handling defendants with serious mental illness. But these promises came too late for Irina Zarutska. The federal case against Brown proceeds on two tracks. First, the criminal prosecution for murder on mass transit. Second, the question of his competency to stand trial. The same mental illness that the system failed to treat now complicates his prosecution. If Brown is found incompetent, he'll finally receive the psychiatric treatment he needed years ago, but only after committing murder. This circular irony defines the case. Brown was too sick for his family to manage, but not sick enough for involuntary commitment. Too dangerous to ignore, but not dangerous enough to hold. Too mentally ill to be fully responsible, but not mentally ill enough to receive mandatory treatment. The system's narrow definitions and rigid procedures created gaps just wide enough for Irina Zarutska to fall through. The mathematics of loss in this case extend beyond one victim and one perpetrator. Irina Zarutska left behind 3 children who now must grow up without their mother. They are collateral damage in a systemic failure that began long before their mother boarded that train. These children, ages 5, 7, and 11, lost their mother not to war in Ukraine, but to institutional negligence in America. The two systems that failed, mental health and criminal justice, continue to operate largely unchanged. Despite promises of reform, no substantial legislation has passed. No officials have resigned. No specific person has been held accountable for the evaluation that was never completed, the commitment that was denied, the releases that shouldn't have happened. The victim impact extends further. Zarutska's elderly parents, who fled Ukraine for safety, now must help raise their grandchildren while mourning their daughter. The senior center residents who looked forward to Zarutska's kindness must adjust to her absence. The other refugees she helped navigate American bureaucracy must find new support. Each represents a life disrupted by preventable violence. Brown's competency evaluation, ordered immediately after his arrest, revealed what everyone already knew: severe schizophrenia, command hallucinations, paranoid delusions. The 60-day evaluation concluded he was not competent to stand trial. He would need months of treatment before he could understand the charges against him. This comprehensive psychiatric assessment, completed only after murder, contained all the information that could have prevented it. The bitter irony is that Brown is finally receiving the treatment his family begged the system to provide. He's housed in a secure psychiatric facility, he's taking antipsychotic medication under supervision, he's receiving daily psychiatric care. Mental health professionals monitor him constantly. The system that couldn't find resources to treat a sick man before he killed has unlimited resources to treat him after. U.S. Attorney Russ Ferguson promised maximum prosecution, seeking the death penalty if Brown is restored to competency. But this raises uncomfortable questions. How can society execute someone for actions taken while severely mentally ill? How can the same system that failed to treat Brown's illness now hold him fully responsible for its consequences? These questions have no easy answers. Meanwhile, in Charlotte, the light rail continues to run. New security cameras watch every car. Additional police patrol the platforms. Fare inspectors check tickets more frequently. The city has spent millions on security theater, on visible responses to make riders feel safe. But none of these measures address the fundamental failure that led to Zarutska's death. 100 cameras wouldn't have identified Brown as dangerous. 1,000 police officers wouldn't have completed his psychiatric evaluation. The final accountability rests not with Brown, whose severe mental illness clouds the question of personal responsibility, but with the systems that had 14 chances to prevent this tragedy. Each missed opportunity represents a specific failure by specific people. The judge who ordered but didn't enforce evaluation, the prosecutor who avoided federal charges, the hospital that released Brown despite family warnings, the jail that ignored his history. These officials made decisions within legal boundaries and standard procedures. No one broke the law, no one violated policy, everyone followed the rules. And that's precisely the problem. The rules themselves created gaps wide enough for a mentally ill man to fall through repeatedly until he landed on a train platform with blood on his hands. Irina Zarutska came to America seeking safety from war. She found death on public transit because 14 different representatives of American systems decided DeCarlos Brown Jr. wasn't quite dangerous enough to stop, not quite sick enough to commit, not quite violent enough to hold. These not quites accumulated until August 22, 2025, when there was nothing quite about the violence anymore. The surveillance footage from that night remains as evidence, a permanent record of systemic failure's ultimate cost. It shows Zarutska sitting quietly, Brown approaching from behind, the sudden violence, the calm aftermath. What it doesn't show are the 14 moments when this could have been prevented. Those moments exist only in filing cabinets and computer databases, in evaluation orders never completed, and commitment papers denied. The question isn't whether DeCarlos Brown Jr. killed Irina Zarutska. The cameras recorded that truth in devastating detail. The question is whether anyone in the chain of systems that processed Brown 14 times bears responsibility for the 15th encounter. That question remains unanswered, buried in bureaucratic reviews and promised reforms that come too late for a young mother who just wanted to help people. The search for accountability continues, but it leads only to empty desks and form letters, to policies followed and procedures observed. Everyone did their job. No one saved Irina Zarutska. In the end, that might be the most damning verdict of all. Not that the system broke, but that it worked exactly as designed, processing papers instead of preventing murders, following procedures instead of protecting people, 14 times.